May it please the court. My name is Kyle Parks. I am the attorney for appellant Kevin Buford, and I would like to reserve maybe 5 minutes for a rebuttal.
Okay.
This case, justices, deal with a juvenile victim a juvenile defendant charged with first-degree felony murder is transferred from from juvenile to adult court, and is given an attorney who has never taken a felony trial before. This attorney then calls his juvenile defendant to the stand, and in his third question asked his client if he accomplished the shooting upon which the trial was there to determine.
Well, so, Mr. Parks, part of your, obviously you just stated it, of your claim is the questioning by counsel at the trial. But the trial transcript is not part of the record before us, as pointed out by the state. How can we determine whether counsel was effective or not by looking at the whole picture if we don't have the whole picture?
Well, so this is the second time this case has been presented to this court.
Okay, but
I might have mistakenly believed that because the record was introduced on the first one, that it might have still been here. So I have to just honestly apologize because I was unaware of that. But when I first filed this, the Attorney General agreed that Mr. Buford's Rule 11 had not been exhausted, and so they conceded the first one. So we had to do the PCR, do the appeal, go back to file the Rule 11, get denied, then go back to a second post-conviction, get denied, and we're here again.
so was the trial transcript, or at least portions of the trial transcript that you're relying on, were they introduced at the PC hearing?
They were. They absolutely were.
So the trial transcript was made an exhibit to the PC hearing?
Yes, the first and the second one.
Okay.
And again, this is a...
Okay. Okay. I'm just trying to figure out, because the state seems to suggest that the record is not proper, is not fully before us. Okay. So that's what I'm trying to figure out. Do we have everything we need, or do?
I tell you this, if you don't, I don't know if it's possible to postpone, but I wouldn't want, we've waited 11 years to do this, and so if it's too late, then I'll have to just fall on my sword and let the court know that I've made this grievous error. But if there is a way to... If
you think it was made part of the record at the trial, and our reading of the record bears that out, then we can order the record supplemented without a problem. So I'll just let you proceed with the merits of your argument, and
I appreciate that.
If we need to enter an order to fix the record, we will.
Okay.
If we can, we will.
Thank you very much.
Mr. Parks, you had started off by saying that trial counsel in the third question of the petitioner at trial asked him if he was the shooter or had participated in that way. Wasn't that already before the jury at that point, though? I mean, hadn't already the recorded statement already been played, and in that recorded statement, the petitioner admitted to being the shooter? So, I mean, if it's already before the jury, where's the harm here?
Because I asked Attorney Wilder what his plan was for having his client admit to the crime, and he says, well, I wanted them to see him as a truthful person. I wanted them to think of Mr. Buford as a good guy. I wanted them to see him as honest, because he was aware that this video was going to come in. But then I said, or at least, and I got to the point where I said, well, that's jury nullification, because you've not presented a defense. You've not offered the jury anything that they could use to mitigate what Mr. Buford's actions were that night. And then you had him confess in addition to having that played. Further, Mr. Wilder introduced, after having been granted relief by Judge Wyatt, that Mr. Buford's prior plea would be left out. The fact that Mr. Buford had pled again. Mr. Buford's had a long journey. His first PCR was for his first attorney because he pled guilty to this charge, believing that he would be susceptible to the death penalty. And so he had a successful post-conviction once he realized that as a juvenile, I would not be threatened, so he took back his guilty plea, right? Then he had a second attorney to carry him through, and then he got Mr. Wilder 5 months before trial.
How would the petitioner, I don't mean to interrupt, because everything that you're saying is valuable, of course. How would the petitioner have responded, though, if the state had asked to say, you know, we've heard the recorded statement, you seem to admit it. I mean, did the petitioner, is he saying that he would have denied being the shooter at trial?
Well, no, he wouldn't have.
Okay. In the absence of that, then, I think that's a pretty critical admission, because in the absence of that, how is there prejudice here on that aspect of on that aspect of ineffective assistance?
I think the prejudice comes from having a child try to be their star witness in their case. I understand the idea that the video would come in and that the jury would hear Mr. Buford acknowledging his involvement with this. Mr. Buford testified that he made the decision with his attorney to testify a day or two before. He said that he had met with Mr. Wilder 2 or 3 times. And, you know, I put at the end of my brief that this burden for prejudice, right, you know, how can it be accomplished? Because it appears that we could always say, well, you know, because of his guilt, we don't have to worry about if the trial was fair. Well, he did it, he acknowledged it, and so how could it be unprejudicial? Well, I don't want to get into strategy arguments, but I literally believe that Mr. Wilder told Mr. Buford that I'm going to argue you were under duress.
Well, okay, you're arguing what you believe happened. What's in the record?
Forgive me. Forgive me. Scott Wilder says that his defense for the trial for Mr. Buford was to show that he was under an undue influence of his dad and his uncle, the 2 co-defendants who had the gun, who forced him to complete this act. He did not ask the jury for jury instructions on duress or undue burden. He did not, in his opening, mention that the defense was going to be that while you might hear that Mr. Buford's involvement, I'm going to also show you testimony that he was not under his control. And then when I asked Mr. Wilder at the PC hearing, why did you abandon the duress or undue burden in defense? He says, well, I didn't think that we had it. I didn't think that we had enough for me to offer that to the court. You know, I asked him, I said, are you aware that it was your responsibility to give that testimony for your client? And so I understand that we cannot go back and armchair quarterback and say, well, if I would have done this strategy, it could have gone differently. I understand that. I am literally saying that Mr. Wilder, who had never been in a felony trial before, took this case at the time when there was a co-defendant that was going to be sitting with him, done by Mr. DeMarco Shabazz. That Friday before they were severed, Mr. Wilder was informed that the co-defendant would be testifying against Mr. Buford. Mr. Buford testifies in the hearing that he did not understand the significance of that. He didn't know what the co-defendant was going to say. Mr. Wilder says that he did not feel like he needed a...
I mean, it's not our job to make credibility determinations, but I have a hard time with that statement. I mean, you know what the co-defendant's going to say. He's going to say something that matches the state's theory of the case. And you also know what he's going to say because you were on the video as being present. So to say I have no idea what he's going to say and we're blindsided by that, you may be blindsided that he agreed to testify you at the last minute. I give you that. But to say that I have no idea how to prepare my defense because I have no idea what he's going to say, that one's a little harder for me to
Fair.
agree with you on.
And didn't he have the co-defendant's statement? I mean, wasn't that provided in pretrial discovery when the two defendants were still joined?
Yes.
So he had some sense about how the co-defendant would testify, right?
I think I jumped topics, and I apologize. I was speaking on behalf of Mr. Buford, that when I asked him if he understood the significance of his co-defendant testifying against him, and I am furthering is, was he prepared? Did he have fruitful conversations with his attorney? Did he know what he was doing, remembering that he was 16 years old at the time? I'm not saying Mr. Wilder didn't know. I'm saying that Mr. Buford told days before that, oh yeah, you've been severed, you're gonna go to trial by yourself, that without asking for what continues, the significance of that is lost on someone who's about to go to trial for murder. And so I don't claim that Wilder should have been able to do it better. I say that this pivot shift, and he didn't discuss it with the client.
Well, and I'll give you that point. I guess I'll follow it up though with this. Did the trial court make a determination as far as the credibility of your client versus Mr. Wilder on that point? Like, you know, the petitioner says he didn't understand what this meant. I don't find that credible, or I did find that credible, but it doesn't matter because they knew what was going to happen. I mean, how did the trial court make a ruling on that? Because that clearly is going to impact how we review it, because if the trial court said, I don't believe your client, he knew exactly what was happening, not much we can do.
I would amend my argument to not necessarily a comparison of credibility between my client and Mr. Wilder, but that it's the absence of nothing. You know, everyone has a right to a fair trial, okay? Well, effective counsel looks different to different people, but Mr. Wilder says in the post-conviction hearing in trial court that he abandoned his defense and did not replace it with anything because he didn't believe that the proof was there. I think that falls below any standard of being able to represent, let alone if you're inexperienced, let alone if you're not that good of an attorney, but to go to trial telling your client, I'm going to argue this defense, and then the record shows that you didn't, and then when asked, why didn't you present it? Oh, well, I didn't think I had it. Then in addition to calling your client, you introduce a guilty plea. So now you've said that your client has completed this act, and you've admitted to the jury that he's already pled guilty to it. After having asked that it be, because the state then obviously says, well, Your Honor, I believe he's opened the door for us to introduce the fact that he's pled guilty to this before. And I understand that under the law, a child defendant is not going to be viewed differently from an adult defendant. But when we're talking about life sentences in the New Booker case that talks about kind of any evaluation of the mental state, you know, I get that him hiring an expert to talk about Mr. Buford's mental health at the time would have been helpful strategy. But if the response to knowing that a tape of your client is going to confess to it, I cannot see any legitimate strategy, even if it went great for Mr. Buford, even if he did excellent on the stand, that could be supported by a fair trial grounds with an attorney who admits that he just made that discussion with his client the day before and elicits a confession and brings up a prior plea and then acknowledges that he does not have a defense. He didn't ask questions to either of the people that testified against Mr. Buford regarding the duress that he said was going to be established in his opening. When I asked him what happened between what you said in your opening, and he said, oh, well, I just didn't think we had the answers. I didn't think it was there. And so I said, why didn't you ask for a pattern jury instruction? He says, because I thought it was I didn't think I had put enough up to ask the judge. And I said, well,
Well, didn't the post-conviction court find, though, that based on the facts, it wasn't warranted to have those
Correct.
instructions?
And now I feel like I'm in the chicken and the egg. I'm saying that, you know.
I don't think it's a chicken and an egg situation. I wonder. You've mentioned a couple of times, and I agree with you, that we should seek to have fair trials. No one's entitled to a perfect trial, but we're all entitled to a fair trial.
Right.
But that may ignore, respectfully, where we are procedurally. And so we're under the Post-Conviction Procedure Act. Post-Conviction Procedure Act says that we would overturn convictions that have been obtained in violation of the Constitution of the United States or of the state of Tennessee. And the sole ground on which the petitioner seeks a new trial on the basis of fairness is ineffective assistance of counsel. That's the sole ground. It's not some kind of general roving fairness.
Sure.
It's specifically tied to the Sixth Amendment right to counsel. And in that context, our law says that a trial is unfair or that counsel has acted ineffectively when the petitioner shows that the deficiencies would have changed the outcome of the trial or would have undermined confidence in the verdict. And I keep coming back to it then. It's not just a simple question of fairness. What should have happened? You know, was the petitioner consulted timely? It's a question of how does it matter? How does it undermine confidence in the trial? So for example, let me go back to one of the examples that you cited. You said we have a severance occurring Friday before the next week of trial is starting. The petitioner doesn't understand the significance of that. Maybe the lawyer does, but the petitioner doesn't. I think our law requires us that we ask, okay, so what? And the so what is, how would it have undermined confidence in the verdict? And so not just kind of out here in the my words, not yours, the nether of fairness, kind of under the rules that we have to go by, how did it affect the outcome of the trial?
That Mr. Wilder's inexperience, him prepping with the other attorney, believing there was going to be a joint defense with a much more seasoned attorney that he acknowledged, understanding that once that severance happens, that now he is going to have his first trial on a felony murder with a juvenile, completely different from what he has been prepping for the 4 months that he's had the case.
So what did not happen that he expected to
A
happen?
continuance. I think he should have asked for more time, even though he admits that he didn't think he needed it. But I believe that, you know, if you take a defense, you abandon it, you don't mention it, then you know, he's saying I didn't think I needed more time, but then you acknowledge that you didn't present a defense at your client's case. You acknowledge that you elicited a confession, and you acknowledge that you brought in a prior guilty plea. And so I believe that if he was looking for mitigation or some type of lesser included, then even though it was not a perfect trial, I believe a fair trial will have allowed the jury to at least consider lesser included offenses.
And so how do we have then knowledge, reasonable expectation, that the jury would have returned a different verdict? Where in the record do we have that? What facts have been proven by clear and convincing evidence that would suggest that?
So, excellent question, Your Honor. I believe the clear and convincing evidence is the lack of the defense done by Mr. Wilder. I think that there has to be an objective standard, right? Like I couldn't go up there naked and be effective, right? I couldn't go up there under the influence. Well, I also couldn't go up there and just say nothing or do nothing. You know, I don't mean to put all of the laurels in what my client should know or thinks, but the whole idea of a fair trial is because the client doesn't know what's happening. The client is having to be guided by the attorney. And if we look at an attorney's defense for a trial of this magnitude, and I believe it's absent, I think the clear and convincing evidence is not, oh, well, this could have happened or that could have happened, but if a fair trial, I think, deserves a defense, even if it's a bad one. And I am saying that Mr. Wilder did not defend Mr. Buford in this trial.
Sure.
And that because of that,
All right. Mr. Parks, it's good to see you again today.
Thank you.
Thank you.
Thank you.
Good afternoon, Your Honors, and may it please the court. I am not Abigail Hornsby. She, for some reason, decided it was important to take care of her beautiful child that she has had. So I'm filling in for her with this. That said, we still ask that this court affirm the denial of post-conviction relief.
So can you explain the record to me?
So I can't, well, a little bit. I'm not as familiar as I might have been if it were my case, but I did do a quick check. I don't think the transcripts were made an exhibit at the trial court.
Is it possible that they were made an exhibit at the original PC and not when it came back, or however that procedurally it worked?
It might be possible. I don't think we have anything from that original post-conviction that I'm aware of in this current record. The only thing that was made an exhibit post Rule 11 denial is a copy of Dr. Montgomery's transcript and his forensic psychiatric evaluation report.
Then
Can
let
we
me-
take judicial notice of our records?
The defendant still hasn't asked for that, but you certainly can if you want to, and if you want to get to the merits, and the state overwhelmingly wins on those grounds.
Let me ask a secondary question to taking judicial notice. Can we take judicial notice if the trial court never reviewed the transcript?
I think this court still can because it's a judicial record, and I think also in part because the trial court, post-convictions have to take place in front of the post-conviction court where the trial took place, and the assumption is that this. I'm honestly not familiar if this is the same trial judge or not.
Because it doesn't always happen.
It doesn't always happen, but I don't know if that plays into whether this court can take judicial notice.
Like I said, we will figure out exactly what happened or where the record is. I just want to get everybody's take on it.
Are you asking us to take judicial notice?
Certainly not, Your Honor. We're not going to do a petitioner's job for him. We have made our argument in our brief, and I'll say again today that without these being explicitly included in the record, that the defendant has waived his challenges because he hasn't supported he hasn't provided sufficient record for this court to review. But in the alternative, if this court wants to, it's always within its discretion, and if it does, we certainly win on the merits as well. Before I really dive into the various grounds of ineffective assistance of counsel, I think it's important to talk about the factual background and what trial counsel was going up against. So in January of 2008, it's pretty uncontroverted. The petitioner shot and killed the victim during an attempted robbery. Not only is there video of him in the general area, there was a neutral bystander who identified him as the perpetrator. His co-defendant identified him as the shooter. And then when police spoke to him, he admitted to being involved in this. So already trial counsel has to deal with sort of this, he done it. How are we going to get around that? And what counsel did at trial was vigorously cross-examine individuals and call his own witnesses. So counsel cross-examined the co-defendant, I think Pirtle, I believe his name is, about how the petitioner's father was, quote, calling the shots, how the petitioner and Mr. Pirtle were sort of scared of the petitioner's father. He called the petitioner to testify on his own behalf, and counsel brought out his fear and concern over the father.
So in what world is it a reasonable trial strategy to have your client take the stand and say, oh yeah, I pled guilty to this?
So I think it's because counsel testified that he'd run through this testimony before, and he was pretty sure that the petitioner was going to let this slip, was going to admit to pleading guilty. And so it's a reasonable strategy if you're fairly confident that your client is going to confess or going to tell the jury that he pleaded guilty, to control how that comes out. And to say, okay, we're going to bring it right out the bat, but we can explain it to the jury that he, here's why he pleaded guilty and then removed it because he didn't actually do it or because we have these defenses.
Well, right, because the defense is duress, is the argument.
I don't think so. So the defense was
Then why'd he do it?
Was undue influence.
Okay.
Because duress is a defense as a matter of law where you were found not guilty. Undue influence isn't as high of a bar.
Okay.
So that's
so the defense is, I'm going to let my client take the stand, in which I know he's going to not only confess, but he's going to confess that he's already pled guilty to this crime.
and withdrawn that guilt.
And withdrawn, but he's pled guilty to it. And I'm doing it because I'm going to argue this undue influence argument that I don't actually argue or don't actually ask for a jury instruction on.
I don't know if there's a jury instruction on undue influence, but even if you don't ask for it, it doesn't make it an invalid defense strategy to appeal to the sympathies of the jury.
Well, what in the record shows us that he actually argued
This
any
court's
defense?
opinion. I didn't mean to cut you off, Judge. But
Yeah, I mean, you're saying that was his defense, was
Yes.
undue influence. What what in the record shows that he pursued that? Because
The cross-examination.
they're
and the
arguing that he abandoned it.
So he had Mr. Pirtle, again, cross-examined him, especially about how the petitioner's father was the one who was calling the shots and directing Mr. Pirtle and the petitioner, how the petitioner was afraid of his father. On direct of the petitioner, he had the petitioner talk about his fear and concern over the father, and going to the guilty plea, what that was
Well,
fleshed out.
let me ask it, I think it's the same question here, but a different way. I mean, it's great that you ask all these random questions as you're crossing and directing people, but if you don't paint the picture at the end of the case, what's the point? So if I'm going to ask, let's say the state calls 4 witnesses and I'm going to call 3. And so I ask all 7 people all these different random questions, trying to put together a puzzle. So I have this picture at the end of undue influence, right? But I don't explain how the pieces get together at the end of trial. What's the point in asking all the questions?
Because you still
And I think that's the defense's point, or the petitioner's point is, okay, fine, you did all this, but at the end of the day, the attorney takes the stand at the PC hearing and says, oh, I abandoned it because I didn't think I had it. You still got to try to paint the picture, do you not?
So that's not my reading of his testimony. His testimony is, I couldn't ask for a duress, like a defense of duress, the legal defense, because we didn't have enough for that. I could still paint the picture for the jury.
How do you paint the picture, I guess, is then
He
my
gave them the picture, or he gave them this puzzle piece. He gave them all of the puzzle pieces. Now, best practice, or certainly going
So did
above
he
and
make the
beyond.
argument, because they make it, your friend here makes it sound like they didn't make the argument. Did they make the argument during closing, whether they asked for the instruction or not? Yeah, this poor kid was so influenced by these 2 people and was under such control, or was, however they want to phrase it, so that the jury understood this is what's happening?
Because the transcript of the closing argument has not been included in the record on appeal, I cannot answer that. But either way, counsel is not required to put the pieces, again, might be best practice to sort of put the puzzle together for the jury and show them. But it's enough to give them the pieces where they can put those together and make the puzzle themselves.
The standard is basically what, and obviously very, very poor paraphrase here, but what a reasonable attorney would do, right?
Right.
You don't think a reasonable attorney would at least expect someone to paint the picture for them and not just say, hey, jury, here are the pieces, let me know how it works out back there in the jury room?
I think it would be great. I don't think it falls below this objective standard of reasonableness. And again, I'll point to this court's opinion on direct appeal where it lauded defense attorney. And I'll quote, defense attorney, quote, did an excellent job in presenting the complexities of the petitioner's relationship with his father and the influence of his father on the petitioner at the time of the crimes. So counsel presented this, and this court lauded him for presenting this difficulty and this undue influence defense to the jury. And then the next sentence it says, but we don't weigh the credibility. That's on the jury, and the jury just didn't believe him.
Okay.
So
Can I go back to first principles maybe here for just a moment? I understand that one of the claims is that there was no jury instruction on duress. I get it. I don't even know if duress is available as a matter of law in a homicide case, because the harm has to outweigh the crime, or the avoidance of the harm has to outweigh the crime. I'm still stuck at undue influence. That's a sentencing factor typically, as I think of it. Is there a jury instruction on undue influence? Is that a defense to a homicide? I have never known that, and I hate to confess that out loud here on YouTube. But that's fine. Is there a jury instruction on undue influence?
to the best of my knowledge, I'm not aware of one.
There's
That
not a statute. There's not a statute out here that says undue influence is a general defense to crimes, like there is with duress. I mean, your friend on the other side challenged trial counsel's decision to nullify the verdict, but I thought that's essentially what it was, hey, there are other factors out here the law doesn't really take account of these factors. Reasonable or not, I think that's a strategy sometimes. I mean, but from first principles, I don't understand why we're talking about undue influence in terms of jury instructions.
I don't think there's any claim about jury instructions at all.
Okay.
Having read the briefs and very vaguely dived into the records, I'm not aware of any issue before this court on appeal that counsel was ineffective for failing to seek something as a jury instruction.
'Cause I don't think it would be available. Do you have anything that would indicate
To the best
that
of
it
my
would be?
knowledge, I
Okay.
don't think there is one, but that doesn't negate it as a defense. Again, especially with the amount of proof that was overwhelmingly establishing the defendant's involvement. He
Asking the jury to turn the other way, the state may have met all the elements beyond a reasonable doubt, but jury, you need to consider these other facts too, and go ahead and nullify it.
are playing to their sympathies of, this just doesn't rise to the level of felony murder because of this.
Maybe not even complete nullification, but at least a lesser included offense.
Certainly, to play, and it is a viable defense strategy when you sort of have all of the damning proof against them to play to the jury's.
Because your friend suggests that's not a valid strategy.
And it just is.
Okay.
A reasonable juror, again, or a reasonable defense attorney, when faced with this overwhelming evidence.
So that was going to be my question. I mean, at some point when we look at that standard, we also have to look at or take into account there may be cases that, as long as the suppression was good, the statement's valid, all those constitutional things, at some point in time the proof's just overwhelming and there's nothing a defense attorney can do other than make sure the state meets its reasonable doubt burden and the statement was correct and the evidence was collected correctly. But at some point, you can only do so much other than just hold the state to their standard, right? Exactly. And counsel even went above and beyond, not just making the state, meet its standard, but still nevertheless appealing to the sympathies of the jury. And it might be a Hail Mary, but it's a valid Hail Mary when you're up against this proof. So I think we've, overwhelmingly established this, or talked about this failure to establish defense. There was a defense established, and I still, in the brief and today, I have not heard any prejudice of what defense a attorney could have presented that would have in any way changed the jury's mind. And the state submits that there just isn't one. This was the best defense that counsel could have come up with, made a valiant effort, and it just wasn't successful to the jury. Does Judge Greenholtz asked this. Does the petitioner have to truly understand what the severance issue is in order for counsel to be effective and not to be prejudiced by the severance?
I don't think so. And again, I want to make sure we hold the petitioner to the grounds that he has presented to this court. And the ground related to this continuance severance thing is that counsel was ineffective for failing to file a continuance. Not that he didn't understand, not that I got the sense today that somehow affected his decision to testify. That is, the claim before this court is that counsel should have requested a continuance. Counsel explained why he didn't do so. He had a statement from co-defendant Pirtle, I believe, many months ahead of time, pursuant to discovery. He had worked closely with co-counsel or with counsel for that defendant. And the court explicitly accredited his testimony that even after finding about this severance and this sort of flipping of a co-defendant, he was still as prepared to go to trial as he could have been. So the petitioner just can't establish any deficient performance there. And again, there's no prejudice. We don't know. The petitioner sort of asked this court to engage in rank speculation as to what a continuance would have, turned over. And we just don't know.
There wasn't anything at the post-conviction hearing about that, was there?
No. I believe the petitioner sort of speculated that he could have gotten some statement by the co-defendant Pirtle. But again, we've already had a statement that he gave to the police that was turned over in discovery. So the issue of a continuance is also without merit. I'll briefly talk about his decision to testify, and I'm still unclear as to what exactly the ground is, whether it was allowing him to testify at all because he's a minor, or specifically asking him those two questions. To the extent that it's allowing him to testify at all because he's a minor, counsel is sort of bound by the petitioner's decision. You cannot prevent a defendant from testifying when they want to testify, and the fact that he was a minor has no impact on that.
And I think even at the post-conviction hearing, didn't the petitioner say he wanted to testify?
He wanted to testify.
Because he wanted to explain all these things.
And so to the extent that he picks out the two particular questions, one about admitting to and being involved in the shooting and one about the guilty plea, we've hashed it a little bit. The shooting makes perfect sense. There's overwhelming evidence. It's no point trying to hide the ball to the jury. Get it out there. Yes, he did it, and here's why. And it's the same thing with the guilty plea. Get it out, control the narrative, and explain Back to
Well, is it really the same thing with the guilty plea? Because they went out of their way to make sure that wasn't going to come in pre-trial.
sure, but then whenever counsel was practicing with the petitioner, he felt that this was coming out, like this was going to slip. And so it was better to control the narrative at that point. Even if you've successfully gotten something excluded, if you know your client's going to bring it in, it's better to control the narrative. And I think he did so here because what that went towards was more discussion about what that plea involved. And he was going to plead guilty, or he did plead guilty, in exchange for testifying against his father. And then he withdrew that so he wouldn't have to testify against his father. That plays into the defense, or at least the presentation to the jury, that he's completely controlled by his father, and he, to the point where he had to withdraw his guilty plea because he's so afraid of this man. And so I think that it's reasonable to not only get that out, but to flesh it out.
So, and I understand all your argument, but that last little bit goes back to my original questioning. That's a very convoluted answer as to why you talked about a guilty plea. Isn't that something you need to explain to the jury on the back end, rather than just kind of leave it hanging out there? Like, you heard my client testify that he pled guilty, that he ended up withdrawing that guilty plea, and let me explain to you why he did that. You heard this testimony, and you heard that testimony, and you heard that testimony, as opposed to not putting the pieces together at the end. I mean, maybe overwhelming, and it may not matter, but I just, when you're talking about the standard that we expect a reasonable attorney to handle a case at, even if it's overwhelming, at least try to paint the picture for the jury. Because if you're looking for jury nullification, you want them to completely understand that relationship between the father and the son, right?
Possibly, but I think there are 2 points to that. First, we don't actually know. Again, the record is sparse as to what was said at closing argument. So maybe counsel did spell everything out and paint the picture and do all this, and then it was great. And again, that's not an issue before the court. Is that it's not that counsel was inadequate in closing argument. It's that the counsel never had a defense in the first place. And when you get that broad, the fact is counsel had a defense. And then there might be a strategic reason, even if you don't want to or get to closing and the trial counsel never fleshed it out. It sort of leaves it in the shadows so that the state can't directly address it. It's still, you're hopefully letting it percolate in a juror's head, but you're not just bringing it out there and putting it on the table for the state to come and eviscerate. So there's potential strategic reasons. It certainly isn't deficient. The last claim that petitioner had, at least in his brief, is this expert to support a theory of duress. But again, there was no duress. It didn't rise to that level. Even the expert that was presented at the initial post-conviction couldn't opine that it would rise to that level. So there's no deficiency or prejudice there. I think those are all the issues that have been raised. Unless this court has any further questions, we ask that you affirm the denial of post-conviction relief. Thank you.
Thank you.
Thank you.
I'll let you have a little rebuttal. I know Judge Greenholz, as usual, took up your time. Go right ahead.
It's been kind of the pattern for the day.
Very first thing I want to say is please take judicial notice of your records. Please.
Very wise. Very wise.
Thank you. Well,
I mean,
Yes.
okay, you've asked that, but I mean, what records specifically? Is there just one prior appeal?
yes,
Okay, all right.
that is correct. Kind of starting with the end regarding credibility, right? AG counsel is correct that the court considered the credibility of the other witnesses and Mr. Buford. But a reasonable attorney, I don't believe, could think that their client could be found credible if they testified that, oh yes, I've pled guilty to this. Yes, I promised to testify against my dad. And then I changed my mind. And now I'm here presenting a not guilty defense to you. I don't buy the worried he was going to open the door himself. And I can, I will go and print these records myself, but that was a point of contention in the hearing because the idea was all Mr. Wilder could say, well, I was worried that Mr. Buford was going to say it. I said, but he hadn't. But when you asked the question about his guilty plea, nothing had come up. And there is a pause, and Mr. Buford, as a deer in headlights, is like, well, I thought we weren't supposed to talk about this. Well, he answers the question now because he is under oath, and his attorney has asked him. The state then approaches and said, John, I believe the door has been opened now based off of attorneys questioning that now we want to introduce and then present the full negotiations of that plea deal that had been rescinded. Regarding the defense, right? I believe the court asked excellent questions saying, well, just simply asking questions of other witnesses is not a defense make. I think we have to determine just because the attorney says that, oh, I believe I put on a good defense, doesn't mean that that's what it is objectively. And to your point, you know, I don't know if it's ever been exhaustively said that when looking for what a reasonable attorney would do, this is an objectable defense. But there are so many things lacking here.
In fact, we don't. So in the post-conviction case, we don't say this is the floor for all cases, because as even Strickland recognizes, what is deficient performance in one case may not be deficient performance in another case. So that's why we don't do that. I keep coming back to hear, Mr. Parks, about what is it about any of the alleged deficiencies of counsel would have resulted in the jury making a different decision, returning a guilty verdict on a lesser included offense, an acquittal, something different? What is there in this record that helps us come to a conclusion that there would have been something different at the end of the day?
It is difficult to you know, prove a negative, but I would offer that.
Well, but that's our burden, though.
Yeah.
Right, and so you and I have had, and I think even Judge Dyer too, we've all had discussions about whether prejudice should be part of the inquiry. At our last argument, when we talked about this, I asked about whether the Sixth Amendment, originally understood, would require it, but that's fun to talk about in the academic journals. We're bound by that as it is.
Of course.
So can you help me understand about how this record meets it?
The first argument I would make is that it is a constellation. I don't know if I can tell the court one specific thing, right? And I understand that that might be where the proof is, but in looking at this case as long as I have, it is a comedy of errors. It is a consistent lack of, I think, any reasonable turn to be made, whether it was the lack of time that Mr. Wilder had the case. I believe he had the case for 5 months. AG counsel talked about going back and forth with, it wasn't that long. He had been appointed the case in February. The trial was in July. To call the client is the client's alone. But at some point, I think that making your client confess, and then, as the court said, not explaining or going into why you've had them confess. And I just believe it's too grievous of an error to ask for a guilty plea to be withdrawn for then you to introduce it yourself and then not try to do anything to adjust for why you've mentioned that.
But as we've kind of discussed, and you started your rebuttal off, we don't know exactly what was said at closing argument.
Right.
So to Judge Greenholt's question, you got to find something to show prejudice. And if he tied it all up in a bow, a closing argument, it may not be your defense, may not be my defense, but it's a defense.
Okay.
So I think the record's going to carry the day here.
Okay. Is there anything I can do to help assist the court in getting that, or, okay.
We'll take care of it. Thank you, though.
Thank you very much for your time. Thank you all.
Thank you.
Thank you both. Call the next case, please.
State of Tennessee versus Lewis Wayne Frazier.